Hey guys, this is attorney Philip Adams with the law offices of Philip Adams here in Shreveport, Louisiana. And I want to talk to you about a Louisiana criminal defense topic, specifically the presence of DNA within the context of the consent defense in sexual assault allegations. Now, DNA evidence routinely arises in Louisiana sexual assault cases, particularly within the context of rape allegations. Given the nature of this discussion, viewer discretion is strongly advised. When consent is raised as a defense, the presence of DNA on the body of the accuser is expected, but is also consistent with consent that might be alleged by the defendant in any given allegation. DNA test results do not, in and of themselves, prove that a rape or sexual assault occurred. They're merely one clue that investigators look at. Without additional facts, the presence of DNA on an accuser simply proves that the defendant's DNA somehow got on or within the body of the accuser. Since DNA is easily transferred, it is important to attempt to find out why and how that DNA is found in a particular location. A DNA examiner cannot testify, for example, as to whether consent existed during a sexual encounter, nor how DNA may have got deposited on a particular location. It's possible DNA could be located on an accuser's body without any direct contact having taken place between the accuser and the defendant because of a phenomenon that we refer to as DNA transfer. There are peer-reviewed papers that demonstrate that DNA can be transferred, in fact, up to 6 times and still be detectable upon swabbing. There's also peer-reviewed research that demonstrates that DNA can be on clothing that can be washed multiple times and still later be detected. So DNA is a hardy molecule that can be transferred multiple times and still be detected. Given this possibility in any given criminal case, it is important to keep this fact in mind when assessing the utility of any discovery of DNA. Only the accuser, the defendant, any nearby witnesses, which often there are not any within the context of a sexual encounter. Usually you're only dealing with the accuser and the defendant, but sometimes there could possibly be nearby witnesses. Those 3 things, plus any physical evidence, are what are used by a trier of fact, consisting of a jury or a judge, in trying to assess the truthfulness of any allegations that are made within any sexual assault case. Now, in contrast with a consent case, what if a defendant denies having ever had a sexual encounter with an accuser? What's in this kind of situation that DNA can become a very powerful discriminatory tool for assessing the truthfulness of the defendant's denial. If the defendant's DNA is found, for example, within an internal vaginal swab taken from the accuser, the defendant's defense might be refuted depending on what the specific facts are. Even still, the consent defense by the defendant might not be refuted. For example, if the defendant's genitalia was being manually stimulated by the accuser within a sexual encounter, and she then later engaged in vaginal stimulation, then you might expect to find the defendant's DNA either within or on the external area of the vagina of the accuser. Why is that? Because during the manual stimulation, assuming no glove was being used, skin cells from the defendant might somehow rub off onto the hands of the accuser. Ejaculate could somehow rub off onto her hands. If she then stimulates herself, one would expect to find DNA from the defendant within or around the exterior of her genitalia. So if an investigator later comes along after this accuser has claimed that she's been raped, simply finding the presence of DNA on the body of the accuser does not prove that the allegation of rape or sexual assault is accurate. You need more than just simply the presence of the DNA. Nor does finding the DNA prove that the consent defense by the defendant in this situation is accurate. You simply have the presence of DNA, because the presence of DNA in this scenario is consistent with both possibilities. It's consistent with the consent defense, but it's also consistent with the rape defense. It just simply cannot by itself tell you if a rape occurred or if a consensual sexual encounter occurred. You would need more than just simply the DNA. Now, if the DNA is present and coupled with, say, prostate-specific antigen, that, or what we call PSA, that is certainly indicative of ejaculation having occurred. So if a defendant indicates that, for example, he was only manually stimulated and did not ejaculate at all and did not penile penetrate this accuser, but then later when she swabbed in her vaginal area, the presence of sperm is found, the presence of this prostate-specific antigen or PSA is found, which would only come about through ejaculation. Well, then we have an inconsistency in this scenario between what the accuser is claiming and what the defendant is claiming. The defendant's consent has suddenly started to become, consent defense has suddenly started to become much more questionable within this context, because he claimed that he had only been manually stimulated, but we have evidence that shows that the presence of ejaculation exists because of the PSA that's found and the presence of sperm that's found. So again, you had to look at the full context of the investigation when trying to assess the truthfulness of witnesses. You can't just look at simply the presence of DNA. Consider also a case in which the defendant's DNA is only found on the clothing of the accuser, even though she claims that she was actually vaginally raped. Now, this is interesting. So let's assume that only internal and external vaginal swabs are taken, and also a swab of her clothing. If there's no DNA found from the internal and external vaginal swabs, then one might at first think that, that's consistent with the defendant's defense that he did not penetrate her in any manner. We only found DNA on the clothing, but didn't find any DNA within the interior and exterior of her vagina. You had to look deeper than that. What if, let's extend this hypothetical, what if the defendant wore a condom that prevented the skin of his penis from making contact with the interior of her vagina and the exterior of her vagina? Well, if that's the case, then one might expect to not find any DNA, and yet he still could have penetrated her. So it's possible that a defendant could have actually committed a rape in this scenario, but there not be DNA found within her vagina or on the exterior of her vagina. DNA's discriminatory power is potentially enhanced when you've got an accuser and then you have a defendant, on the other hand, who have stories that contradict one another, such as when somebody claims consent and somebody claims that there was not any consent. On the other hand, if a defendant claims consent and the accuser claims rape or sexual assault, one would expect to find the presence of DNA, even though both of these claims are technically inconsistent with one another. In which case, you'd have to look at additional factors like whether there was consumption of alcohol or drugs, or there are contradictory accounts between what these witnesses are saying and what maybe other witnesses are saying, or are these accounts contradicted by other physical evidence? Is there inconsistent behavior? Or are there multiple retellings of these allegations that are inconsistent? Are injuries present that could be used to infer possible force or violence during this supposedly consensual sexual encounter? These types of sexual assault cases often depend highly on witness credibility and are very fact intensive. To complicate matters, alcohol consumption is often consumed by parties who are involved in sexual assault allegations, not always, but often. To ensure that you're not wrongfully convicted, it is paramount that you obtain an attorney, or at least consult with an attorney, who is knowledgeable and informed about DNA forensics and the science of DNA if you're facing a rape or sexual assault allegation. While you don't technically have to have an attorney and you can represent yourself pro se, you can benefit strongly by having an experienced practitioner who is well versed in the science of DNA. Take care.